Okay, let us welcome to the fourth module of business law. So, under this act, it is known as Partnership Act 1932. But in the business law, two important laws. One is Partnership Act 1932 and also the Sale of Goods Act 1930. Both the laws were included in the Contract Act 1872. So we will discuss now the Partnership Act and a little bit of Sale of Goods Act 1930. So let us see under the Partnership Act. This is the Act number 9 of 1932 and it was issued on the 1st October in 1932. So there is a section called 69 section in this act. It was really effective from 1st October 1933. Originally, it was not effective. So there are 10 definitions under this act and there are 8 chapters and there are 72 sections. This is called Partnership Act 1932. But before that, the Sale of Goods Act 1930, it was the Act number 3 of 1930 and it was issued on 1st July 1930 and there are 14 definitions under this act and there are 7 chapters and the total sections under this are 64. So what will happen? We will just discuss both the act here. Under the Partnership Act, there are 8 chapters. So let us go to the chapter. So there are 8 chapters under Partnership Act 1932. The first chapter is preliminary and particularly the definitions. There are 10 definitions under this act that has been discussed under the first chapter. And there are the second chapter which is really known as the nature of the partnership. And third one is the relations of partners on another that has been discussed. And the fourth chapter is relation of partners to third parties. And the fifth chapter is incoming and outgoing partners. Chapter 6 indicates the dissolution of the firm, partnership firm. And then 7th chapter is the registration of firms. And finally, the 8th chapter, which is really the supplemental. So under the Sale of Goods Act, there are 7 chapters and that is particularly the first chapter deals with the preliminary. All the definitions are here. And the second on the formation of the contract, which is related to the Contract Act 1872. And the third chapter deals with the effects of the contract. Fourth chapter deals with the performance of the execution of the contract. And the fifth one is the rights of unpaid sellers against the goods. And sixth one is the suits of breach of the contract, if it is. And finally, the 7th chapter deals with the miscellaneous relating to the Sale of Goods Act. So these are the overview of these two acts, Sale of Goods Act 1930 and the Partnership Act 1932. So I am going to now discuss in detail the Partnership Act 1932. I mean the birth, if we can just check, the Partnership Act was born in 1932, but before that already we discussed and told that this act is linked to the Contract Act 1872. Originally it was included in that act, but in the year 1932, in the form of a new independent act titled the Partnership Act was born. So what is partnership? It has been defined under the section 4, which tells us that a partnership is the relationship between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. That is the definition of partnership. That means there must be minimum 2 persons. And in the Partnership Act, there are maximum 20 partners can be. And if it is a banking business, then the number of partners will be 10. So what are the elements of partnership? There are different elements, valid elements. So let us see. The first element is the agreement. Agreement among the partners, because those who are coming to form a partnership business, they must agree on the terms and conditions regarding the capital, how much they will mobilize individually. It may be equally, it may not be equally, and also the another part is the profit sharing ratio. It may be equal, it may not be equal. So all these are the elements of partnership. Essential elements of a partnership firm is the most important one is the agreement among the partners. If the partner is two, then between the partner. So it must be formed by an agreement, either in written or in oral. That means it must be written, it is not mentioned in the law. It may be, it may not be. Then the profit sharing is the second element. That means the partner, how much they will take and what will be the proportion of the distribution of the profit. So here in the law it is mentioned partners share the profits of the business, and it depends on the agreement what is mentioned in the agreement. It may be equal, it may not be equal. Then the business activity, what they will do, what type of business they will do. It must be lawful business activity. And finally, the mutual agency. Partners act as agent for each other. That means they are partner, it is true, but also they are mutual agent equally. So types of partners. So there are different types of partners, like there are active partners. Active partners means they participate in the day-to-day operation. Sleeping partner, that means they invest capital only but does not engage in the management. Nominal partner lends name and reputation, does not invest capital or participate in management. Partner by estoppel, not an actual partner but represent himself as one. Partner by holding out, allows others to believe that he is a partner. So there are 5 different type of partners mentioned in the Partnership Act 1932. So formation of partnership means how we can start the business. So it is mentioned that agreement is the key, but the question here, if there is no agreement, what will happen? The Act clearly mentioned that there is an agreement already printed in the Act, presented in the Act. So if there is no agreement, that based on that agreement, the problem will be resolved. So it can be, agreement can be written, it can be oral. So registration is not mandatory, but advice is in Bangladesh that you must take some registration, maybe in the form of trade license, or you can also register it with the help of RJSC, that is Register of Joint Stock Companies. You can get the registration. So what is the firm name? So name is also an important matter in this case. So the name under which business is conducted, so that is also mentioned. You can, if it is more than 2, then maybe there a name third, a name maybe you have to name the business, and it is also important precondition mentioned in the law. So rights and duties of the partners. You see, it is a formal enterprise, may be registered and may not be registered, but they have trade license, and also there is a partnership deed also mentioned in the law. So based on that, what are the rights and duties are discussed. So the first one is the right to participate in the business management. This is number 1, if he is active member, active partner. Right to access funds, books and accounts. And the third one is the right to share profit and losses. So these are the 3 fundamental rights an active partner in a partnership firm they enjoy. So what are the duties? The first duty is to act in good faith, duty to render true accounts, duty to indemnify the firm for losses caused by fraud. So these are the fundamental three different duties and three different rights the partners enjoy as per mentioned by the law, Partnership Act 1932. So there is a conclusion, particularly in terms of rights and duties, that is, partners are jointly and severally liable for the debts of the firm. That means the liability of the partner is unlimited. So what does it mean? Unlimited means if the enterprise profit or capital is less than the amount of debt, then they have to pay the debt taking money from his own fund. That is why the liability of the partners are unlimited, especially in case of partnership firm. Property of the firm, that is, it includes all property and rights brought into the firm or acquired for the firm. That is the property of the firm. Dissolution of partnership. So before discussing the dissolution, the partnership agreement is the most important document, especially in case of partnership business, and all active partners basically they are liable and they should play their active role in the business. So they always work together, and here their shared vision, they must believe they have unity to work. And finally, sometimes we see that the partnership firm may not be keep continued, so their dissolution sometimes it becomes necessary. So there are two types of dissolution discussed in the law. The first one is the voluntary dissolution. So by mutual consent or as per agreement, the firm can be dissolved. And there is another one that is called compulsory dissolution, and it must come from the court order under specific circumstances. So there are two ways a partnership firm can be dissolved. One is voluntary way and another is compulsory way. Registration of partnership. How we can, without registration, partnership can start. But what is the way we can register it? That is what is the procedure? So here it is mentioned that there is a Form 1, and submit that Form 1 and partnership deed to the Register of Joint Stock Companies and Firms, RJSC. So what is the benefit if I can get the registration? The benefits are it's a legal recognition and ability to sue in court. The question is this: partnership is an enterprise, an independent artificial legal citizen. So somebody can sue against the firm or firm can sue against the person. So there are two ways. It's a legal recognition, and the another way is the ability to sue in the court. So protection against third party claims. So these are the process of registering of a partnership firm. So reconstitution of the firm. When really we need reconstitution? It occurs due to admission of a new partner, retirement of or expulsion of an existing partner. So in both the cases, we need to actually reconstitute the firm and change in profit sharing ratio. So if it happens, then we have to reconstitute the firm. Minor as a partner. Sometimes already we have discussed that in the Contract Act that a minor cannot sign any agreement because he or she is under 18. So that is also a constraint. But here, minor, whether in partnership firm, whether a minor can join or not. It is mentioned here a minor can share in profits of the fund but cannot be a partner. So a minor can take profit, but a minor cannot be a partner. This is number one principle. The next one is upon attaining majority can choose to become a partner. So If the majority, accepts the decision, then someone can be the partner of the partnership firm. There are two ways, but it must be informed to the register of joint stock companies. Expulsion of a partner. That means a partner can be expelled if the partnership agreement provides for it. That means partnership agreement or partnership deed is basically the solution of resolving all the types of disputes. So the question of a expulsion, yes, it is possible if the agreement provides for it. Retirement of a partner. Yes, a partner may retire by giving notice as per the partnership agreement or partnership deed. Only then it is possible. Death or insolvency of a partner. So there are two things are very important. Or one is a partner can be declared as insolvent. A partner may be died. If it is, then what will happen? The firm may be dissolved unless otherwise agreed upon. That is mentioned in the partnership deed, and that will be applicable here. Transfer of partnership interest. Can I transfer my partnership interest? A partner can transfer his interest in the firm but does not make the transferee a partner. That means someone or some partner may transfer his partnership interest, but that person may not be the partner of that partnership firm. So legal status of a partnership firm. So no separate legal entity unless it is registered. When the firm is registered under the register of joint stock companies, only then separate legal entity will be emerged. If not, then there is no separate legal entity. There is another that is called partners are personally liable. Why it is? Because if the date of the firm or if the loan of the firm is unable to generate money from the business, then individually the personal will be liable. That is why it is called unlimited liability. Taxation of the partnership. The profits are taxed in the hands of the individual partners. That is, partnership's income or partnership profit is taxable in the present law of the country. So comparison with companies. So let us see the difference between the company, that is private limited or public limited company, or partnership firm. So in partnership firm there is no separate legal entity, but if it is registered, then certainly there will be separate legal entity. Partners are personally liable. This is called partnership. But in company, separate legal entity, because their liability is limited. That is why it is called limited liability, or partnership unlimited liability if it is not registered. Challenges in partnership. So what are the possible challenges? We have seen that the difference between company and partnership. If it is not registered, then in the partnership firm, liabilities are unlimited. But in the company, the liabilities are limited. So after that, as a firm, what are the challenges usually a partnership business can face? So one of the important areas, particularly the challenges always there, that is called disputes among partners. The second one is the management issues, and the third one is the legal complexities. So these are the challenges usually in the partnership firm, but in the law it is also discussed, these three important issues, and there are always chances of the crimes, and accordingly the settlement will ultimately lead to the court. So through court the challenges may be overcome. Advantages of partnership. Yes, there are so many limitations, but in spite of all these limitations, there are advantages of partnership. The first one is the shared responsibility. That means unity is all. unity is a strength. We have, we know that. So there is a possibility of shared responsibility in partnership business. So that is combined skills and expertise. That means this is a possibility that you can combine different skills and experiences under the one umbrella, which is known as partnership business. And finally, the flexibility in management. These are the three important advantages of a partnership firm. What are the disadvantages of partnership? Already we have a little bit explained earlier. That is, the first disadvantage is unlimited liability. That means if your firm is unable to pay the obligations of others, then court may decide to sell your own property and pay the obligations. This is called unlimited liability. This is the greatest disadvantage of partnership firm. Potentials for disputes, because we know that when you work together more than 2, 3, 4%, what will happen? Many men, many minds. So there are chances, potentials for disputes lead to, to the court cases. And finally, it mobilizes a limited amount of capital. And that is why you cannot really make it very big business. That is the limitation. But in case of company, you can mobilize a big amount of capital and you can go for a big investment as well, which is not possible. Finally, let us conclude. Partnership Act 1932 provides a legal framework for partnership business in Bangladesh, balancing the interest of the partners and ensuring legal clarity. Thank you.